we also filed a reply, all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your lordship to determine that in other ones. But the one asking for stay of proceedings, my lord, our argument is to the fact that the statute does not permit your lordship to grant any stay or proceedings or injunction. So we ask your lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter bill, the latter application with respect, is an abuse. In any event, none of them merits. We urge your lordship to dismiss it.
Please, let's save the time of the court.
We are praying your lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my lord.
Thank you, sir. Defendant, you have one or two words to say?
Most certainly, my lord, and I'm most grateful.
Would you like to learn how to trade from an experienced ex-City trader who can share his professional insights and experience?
My point is a very simple one, my lord. Very, very simple.
Benjamin Madubugu inspecting the radio transmitter and taking ownership and declaring it as a game changer, where Radio Biafra will be broadcast through. Following an instruction from his superior, PW4 obtained a search warrant and on the 28th day of October 2025 proceeded to the village where Benjamin Madubugu was and retrieved the radio transmitter. PW4 stated that when they opened the container, they found only the transmitter in it and asked Benjamin what happened to the other items, and he said the defendant came to inspect the radio transmitter with one individual named Chimeze, who took the other items away, leaving only the transmitter in the container. He said Benjamin Madubugu wrote a statement on the 3rd day of November 2015 at the DSS headquarters, and he confirmed the result of the search. Benjamin Madubugu, when asked, did not produce any custom paper. Benjamin was initially arraigned along with the defendant until he jumped bail and the case was severed. He said, iPod has made life difficult in Southeast due to the sit-at-home order of the defendant, as well as the violence unleashed by iPod. Further, the Eastern Security Network, which is the armed wing of iPod, bears arms, engages in guerrilla warfare, where they attack security agencies such as the police and the Nigerian army. They also ensure compliance with the sit-at-home order. PW4 stated that in a particular broadcast of 30th day of May 2021, the defendant issued threats that anyone who defies his order of sit-at-home by opening their shop should be killed and the shop burnt. PW4 explained that Ahmed Gulag, the former senior special assistant to the former President Goodluck Jonathan, was killed on the day declared to be a sit-at-home, that he tried to take another route to the airport in Owerri when he was shot by iPod terrorists. PW4 said he was the first person at the scene and he found the lifeless body of Gulag on the road. He said that from the feedback they got from residents of Southeast, the sit-at-home order had depleted the economy and activities in Southeast, and the people were living in apprehension for their safety. PW4 also said that he knew one Ikonzo, identified as one of the dreaded commanders of Eastern Security Network, which real name is Kanikayo Andy. He described Ikonzo as a ruthless commander who took direct orders from the defendant. PW4 further stated that Ikonzo was killed on the 24th day of April 2021 after masterminding attack in Olu, Imo State, during which he mobilized Eastern Security Network members and other adherents of IPOD to attack the correctional centers and facilitate the escape of numerous inmates who were in lawful custody. He also attacked the police headquarters, and a lot of police stations or police officers were killed. However, he was involved in a shootout with security operatives after a manhunt was declared on him. The shootout led to his death. PW4 stated further that on the following day, 24th day of April 2021, the defendant made a broadcast in which he declared that Ikonzo would be buried specially in the manner of the Oba of Bini, meaning that he would be buried with human heads. Consequently, the defendant's order is meant to procure human heads for the burial of Ikonzo. The order was carried out by one of his junior commanders named Emery Uzoma Benjamin, known as Oye Ami. That when Oye Ami was arrested, he wrote in his statement that the defendant ordered him to get the heads, but he was only able to secure 30 human heads. At the scene of where the transmitter was kept in the premises of the Department of State Service, PW4 continued its evidence when he stated that the container containing the transmitter was recovered from the premises of one Benjamin Madugu, wherein the defendant had smuggled in the radio transmitter into the country. The container also had some household items in it, which were later removed. Upon the matter being adjourned back to the court, PW4 confirmed that Benjamin Madugu indeed made a statement before the DSS. During the statement taken, he had his lawyer, one Vincent Obeta, present with him. PW4 also stated that upon retrieving the radio transmitter, they brought the defendant and Benjamin Madugu together and confronted the defendant with the evidence. He stated that the defendant accepted ownership of the container and that the radio radio transmitter. He also exonerated Benjamin Madugu by stating that the items were only kept in his house and that Benjamin Madugu does not own the items. PW4 also stated that the DSS wrote to the Nigerian Broadcasting Commission to confirm and come and inspect the transmitter, which they duly came and wrote a report of the findings. The conclusion from the report as read by PW4 is that the station known as Radio Biafra was not licensed by the Broadcasting Corporation of Nigeria. Neither does he have any permits to operate in Nigeria. That for an organization to bring in a radio transmitter, it must apply for permission from the regulator, who is in turn right to the security agencies such as DSS and the National Security Advisor for clearance before the regulator issue a license to import this transmitter into Nigeria. That in this case, no such license permission was obtained by the defendant before importing this transmitter. PW4 referred to a newspaper story where the defendant had ordered an attack on prison in Imo. The defendant had ordered members of IPOD to kill security operatives. Also, that investigation revealed that the defendant, having ordered members of IPOD to bury Ikozo in special way by using about 2,000 human heads. His men were only able to get 30 human heads. Efforts were made to arrest these IPOB members in Olu, in a village bordering Anambra Valley. They met some members of IPOB with human heads hanging from a wire mesh, and they also saw some of them eating human flesh, which they claimed was for spiritual fortification. They also saw as well where they dumped victims and beheaded bodies into. PW4 stated that it was part of the operation which comprised the DSS and the Nigerian Army. He also stated that the defendant has never denied making those state broadcasts and was even proud of making them. PW4 also stated that record shows that between 170 and 200 security agents of the federal government were killed by IPOB and Eastern Security Network all over Nigeria of Imo State. PW4 stated that the defendant was in the habit of making inciting statements ordering his men to carry out attack on security agents as well as political figures such as Hope Uzodinma,
the governor of Imo State. He stated that their mode of operation is that they move in group in Siena and others confiscated vehicles, and from there they launch attack on security operatives.
They also set up checkpoints. He was the first to get to the scene of that attack where he found the disease in a pool of his blood. He was informed by the divisional police officer in the area that the disease was in a taxi heading for the airport when the IPOD and Eastern Security Network armed combatants identified him as one of their checkpoints and opened fire on him. The driver of the taxi identified himself as an Igbo man, but the disease, even though he claimed he was an Igbo man, could not speak the language, and having observed a prayer mark on his forehead, his attacker shot him. The body was later moved and conveyed in a plane to Abuja on the directive of the former Secretary to the Government of the Federation, Boss Mustafa. PW4 stated that between 2019 and 2022, he was in charge of security enforcement in Imo, and he witnessed firsthand the activities of the defendant and his men. PW4 stated that the defendant is the leader of indigenous people of Biafra, IPOB, as well as the founder and operator of Radio Biafra. He testified that the defendant used the said with federal government as part of his agitation for the establishment of Republic of Biafra under cross-examination. PW4 stated that he did not sign any of the investigation reports, and also that the transmitter came in the country through the Tinkan port in Lagos. He said he did not find out the date the transmitter came into the country, as same was smuggled into the country, and that it was not part of his schedule to find out the date. That there are no records to show it came in through Lagos, save for the statement of the defendant that it came through the Lagos port. He also stated that IPOB was formed outside Nigeria, and that Radio Biafra was operated outside Nigeria but broadcast within the territory of Nigeria, as it was an online platform. He further stated that the defendant was arrested in Lagos with his broadcasting equipment. He said it is not the duty of the DSS to find out if Radio Biafra was registered in London. PW4 stated that he and one of the officers were sent to Ubuluzi to recover the transmitter, that they reported to the DSS headquarters in Awka, and from there they proceeded to where the container was located, using coordinates on video showing the containers. They testified that the container contained one other items, including 2 pump-action guns, one of which was found in the bedroom of Benjamin Madubulu, that the said Madubulu is facing a charge of illegal possession of weapon before Inyako jail. He also stated that even though the defendant stated that he does not like violence and crime, and that churches and other places of worship should not be attacked, his broadcast of 20th, 24th, 25th October 2020 clearly incited people to kill others. That the main thrust of the defendant broadcast is the killing of Fulani herdsmen by raiding the forest of Southeast with AK-47, killing the innocent. He said he is not aware of any Fulani herdsmen being prosecuted for attacking people in Eastern states. PW4 admitted that Gulak conducted the primary elections that led to the emergence of the governor of Imo State, Hope Uzodinma, and that satisfaction over the declaration of Hope Uzodinma was still festering. He stated further that even though Ahmad Goodluck was with 2 other persons in the taxi, he was the only one killed. IPOB sometimes do not kill Igbo person who violates the sit-at-home order. He admitted that the defendant said IPOB will compensate the person which lorry of onions was hijacked, but he does not know if the promise was fulfilled by the defendant. PW4 stated that it was the police who investigated the killing of Ahmed Gulak. He said during the sit-at-home, everywhere, including farm, are usually deserted, and it is dangerous for anyone to be outside. PW4 also stated that the Nigerian Broadcasting Commission monitors the frequencies of every radio station in Nigeria, and they were able to monitor the frequency of Radio Biafra. He stated that in July 2021, he was instructed to lead a team of officers. He was instructed to lead a team of officers of the and other investigators to travel around country to obtain and collect record of activities. Travel around country to obtain and collect record of activities that security agencies in the states visited, particularly the states in the southeast and the FCT, obtaining reports of dates and death certificates of security Akwa the prosecution of defendants under the Repealed Terrorism Prevention Amendment Act 2013 upon a Section 1 sub 2 is unconstitutional, unlawful, and cannot ground criminality. Is unconstitutional, unlawful, and cannot ground criminality. 3. An order striking out or permanent the amended charge dated 14th January 2022 for being barred by double jeopardy, having the same factual ingredient as can 6 to 14, earlier struck out by the Federal High Court on the 8th day of April 2022. Federal High Court on the 8th day of April 2022. 4. Noble Lord laid Nikki Toby, GSC of blessed memory in INEC and Musa citation supplied, heard and enunciated on the principle of fair hearing. The defendant ruling of 7th November 2020 proceeded to foreclose the defendants. This matter was filed in 2015, and due to the delay as a result of appeals and other issues, same was assigned to this court in March 2025. Prior to this, in 2017, the defendant was alleged to have jumped bail and escaped from Nigeria, and for in accordance with Section 135 of the Evidence Act 2011. Also see the case of Edevie versus Orogo. Crime or quasi criminal are made in any matter, even in a civil matter. Affidavit evidence will be insufficient, which is beyond delay in this trial was empty of the ruling and laying foundation for usual delay, which has been the trend since 2015. Based on this, the court added that the medical panel ascertained whether the defendant is fit to stand trial. It is actually a mystery to this court that a defendant who is standing trial would delay his trial, his own trial, while shouting that he is being denied his right to fair hearing. Usually, it is the prosecution that delays the trial as his life is not on the line. But in this case, the reverse was the case. The order of the court to ascertain his fitness was strategic to nip in the bud any attempt himself shows without that he is indeed fit to stand trial, thus corroborating the conclusion reached in the report by the panel set up by the President of Medical Association. Even without the medical reports, the fitness of the defendant is clear to any reasonable person who observed him in court. His claim of being low on potassium in hospital are not such that render him incapacitated, and abreast of all the happening in the trial, and demonstrated full understanding and fitness after taking over his defense himself from his counsel. I therefore hold, without doubt, that the defendant is fit to stand this trial. The court then proceeded to give the defendant 6 consecutive days to open and close his defense. Counsel to the defendant, Chief Kanu Agabi, had prayed the court to allow the private consultation between the defendant and his counsel in preparation for his defense, despite the fact that there was no bono, which were all rejected. Address filed by him will be deemed as his final written address in this suit. Pursuant to this order of the court, on the 27th October 2025, the defendant filed a motion for be treated as the final. Despite this magnanimity by the court, the defendant did not make use of this opportunity, decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel who he had earlier disengaged to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denied adequate facilities to prepare for his defense. He had enough time to prepare. He had been represented by senior advocates within the Commonwealth. The London scheme for extradition within the Commonwealth enables Nigeria to request and surrender fugitives to member nations of the Commonwealth. On the other hand, extraordinary rendition is an extrajudicial measure to forcefully bring suspect or defendant to the country against which an offense is committed. These extraordinary measures may include adoption. This versus Nnamdi Kanu in SC/C CR/13C1 2022, where my noble Lord Agim JSC had, and I quote, generally abduction or kidnapped or any form of illegal removal of an accused from the territory of a state cases of Kell versus Illinois. 119 U.S. 436 342 U.S. 519 1952, where a messenger from the United States, even though he had been sent to Peru with a valid warrant and instructions to obtain the defendant with the cooperation of the local authority, addressing Kell's due process challenge, the Supreme Court of the United States held that the party should citizen was adopted and brought to the United States as the direction of the Drug Enforcement Administration. The Supreme Court of the United States held it did not affect the validity of his trial in the United States. Failed to produce any document in proof of these forged documents. Allegation of such forgery in any civil matters is criminal in nature. Therefore, proof is beyond reasonable doubts. See also the case of Muni versus Federal Republic of Nigeria, among other authorities. The evidence in proving an unlawful extraordinary rendition must be oral evidence obtained which allows the adverse party to cross-examine the defendant on his oral evidence. The appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were rendered, which were retained by it, being charges allegedly committed by the appellant prior to his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country on the 27th day of June 2021, in violation of international and state law, the lower court or indeed any court in the country is divested of jurisdiction to entertain charges against the appellant, and I so oath, unquote. When this issue came up before the Supreme Court, the Apex Court, in Federal Republic of Nigeria versus Kanu in SC/CR/1361/2022, delivered on the extraneous to the statutory jurisdiction vested or conferred on the trial court to try or adjudicate over the offences in question, particularly after the valid arraignment of the respondent and his plea thereto. The procedure used in producing the respondent to face his trial after the arraignment and plea to the offences, and after jumping the bail granted to him by the trial court, cannot reasonably be said to deprive or rob that court of the requisite statutory jurisdiction to adjudicate over or try the offences in questions in the after arraignments during the pendency of the proceedings in court. The Court of Appeal has introduced a departure from the established case law on the points in Nigeria. What is not clear is if the departure is limited to cross-border cases or include cases within Nigeria. But the erudite restatement of the House of Laws in R versus Osprey relied on by Court of Appeal are couched in terms that suggest that they apply to all cases. This profound judicial restatement appears to give paramount consideration to preventing executive lawlessness, protection of the fundamental rights of the accused, preservation of the rules of law, promotion of rights for territorial sovereignty of states, enforcement of international law, adherence to due process of criminal law to ensure that prosecution does not benefit from abuse of its power and abuse of court process. But the reality in Nigeria peculiar situation is that no allegation of commission of a crime will be tried if the court declines jurisdiction to try a criminal case or invalidate it because of the violation of fundamental rights of the accused person or other unlawful action of the prosecution that occur in the process of investigating a criminal complaint against him or in the process of initiating the criminal case against case arising from such complaints or in process of bringing him to court or in dealing with him while he is standing trial. This is because criminal law enforcement officers routinely engage in unlawful actions and brazen violation of fundamental rights of suspects in the investigation and prosecution of virtually all criminal matters. The effect of the holding of the Supreme Court is that, notwithstanding the legality or otherwise of how the defendant was brought, the line set by the Supreme Court as the apex court of the land, his decisions are final, override all other courts, including the Court of Appeal, which defendants has erroneously relied on heavily. Kindly see Section 235 of the Constitution of the Federal Republic of Nigeria, 1999, and the case of Adama Tanker Brokering Services Limited against CBN citation supply. The fact in this case is more distinguishable. The fact in this case is more distinguishable even than in Kelfibri case in U.S. with respect to the effect on the jurisdiction of court to try the defendant as held by the Supreme Court per Gaba JSC. In that case, the defendant in 2021 will not deactivate the jurisdiction of the court activated since 2015. I hold without hesitation that this is an exception to the effect of extraordinary rendition in international law. Even if the extraordinary rendition was wrongful, the remedy for it is at best monetary damages in civil proceedings. The court is aware that a court in Kenya had ruled on this issue and awarded monetary damages to the defendant. The court in Kenya had awarded monetary damages against the Kenya government for gross violation of defendant's rights, fundamental rights. The defendant cannot benefit from monetary damages awarded to him and seek a further relief of his trial being vitiated, particularly seeing the nature of the offences, which borders on terrorism. This is similar to the enforcement of fundamental rights to personal liberty in Nigeria. A successful application for unlawful arrest entitles the applicant to compensation or an apology, but it does not extend to vitiating a criminal trial where the charge has been preferred against him. Consequently, this issue is resolved against the defendant, since that it is based on repeat law. The general rules regarding a charge is that it must be premised on written law. See Section 36, sub 12 of the Constitution of the Federal Republic of Nigeria, and it provides, and I quote, subject as otherwise provided by this Constitution, a person shall not be convicted of any criminal offense unless that offense is defined, and the penalty, therefore, is prescribed in a written law. And in this subsection, a written law refers to an act of National Assembly or a law of states, any subsidiary legislations, instrument under the provision of the law, unquote. The above means that a person to be tried and convicted, the offense must be in existence and provided for under law, a law in force at the time. See the position of the Court of Appeal in Daniel versus Federal Republic of Nigeria, citation supplied. The law is also settled that the trial and conviction of any person upon the repeat law is a nullity. This was the position of the Court of Appeal in IGP versus Ogundimu, citation also supplied. A law once repealed a fundamental political, constitutional, economic, or social structure of a country, unquote. The above provisions were enforced 2 years before the defendant's arrest in 2015, meaning this court had requisite jurisdiction to try him then. his initial trial, therefore, was based on an existing and valid legal foundation as at then. This instance means that at the time he was charged, the Terrorism Prevention Amendment, if the defendant's offences were allegedly committed after the Terrorism Prevention Act 2022 have been enacted, the 2013 Act, under which the charge was filed and brought, and the respondent was properly and validly arraigned before the trial court. Put another way, the offences the respondent was arraigned for before the trial court are offences known to and specifically provided for under and by the provision of 2011 Act as amended by 2013 Act. The offences are therefore recognized laws of the Jurisdiction of Nigeria 2004. There can be no reasonable dispute that the criminal code is an extant and publication of all the acts or statutes, the subsidiary legislations, enactments of that is not cap 45 or cap C of the charge against the respondent. Rather, Criminal Code Act is chapter 38 or chapter C38 in the laws of be enforced and have effect as sealed, made, issued, given, or done under the corresponding provision of this Act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or cause of actions pending or existing immediately before the commencement of this Act under any of the repealed Acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The import of this provision, particularly section 98.3, is it serves as a saving provisions which ensure that the amendment of the Act does not affect the validity of Terrorism Prevention Amendment Act 2013. I must start the resolution by outlining the effect of the action of the defendant in failing to put in his defense, despite several opportunities afforded him by this court. Generally, in criminal trial, on the uncontroverted evidence led by the prosecution. With respect to count one of the charge, the defendant is facing a charge of committing an act. For the second ingredient, the prosecution led evidence showing that the action of the defendant in making broadcasts threatening that people will die constitutes for dictionary is, I quote, the unlawful use of violence, intimidation, especially against citizens in the pursuit of political aim, unquote. It is also important to explain what constitutes terrorist acts. Section 1(2) of the Terrorism Prevention Amendment Act 2013 provides us, and I quote, in this section, act of terrorism means an act which is deliberately done with malice, aforethought, and which A, may seriously harm or damage a country or international organizations. B, is intended or can reasonably be regarded as having been intended to 1. Unduly compel a government or international organization to perform or abstain from performing any acts. 2. Seriously intimidate a population. 3. Economic loss. 4. The seizure of an aircraft, ship, or any means of public or goods transport and diversion, or the use of such means of transportation for any of the purposes in paragraph B4 of this subsection. 5. The causing of fires, explosion, or flood, the effect of which is to endanger human life. 7. Interference with or disruption of supply of water, power, or any other fundamental natural resources, the effect of which is to endanger human life. D. An act or omission in or outside Nigeria which constitutes an offense within the scope of counter-terrorism protocol and convention duly ratified by Nigeria. The Supreme Court, by PJN, heard in Abdul Mumuni versus Federal Republic of Nigeria this act is liable on conviction to imprisonment for life. Section 46 of the Act provides terrorism means any act which is a violation of the criminal code or the penal code and which may endanger the life, physical integrity, freedom of, or cause serious injuries or death to any person, any number or group of persons, causes or may cause damage to public properties, natural resources, environmental or cultural heritage, is calculated or intended to intimidate, put in fear, force, coercion, or induce any government body or institution, the general public, or any section thereof, to do or abstain from doing any act or to adopt or abandon a particular standpoint, or to act according to certain principles, the delivery of any essential service to the public, or to create a public emergency or create general insurrections in a state, any promotion, sponsorship of, contribution to, command, aim, incitement, encouragement, attempt, threats, conspiracy, organization, or procurement of any person with the intent to commit any act referred to in paragraph A, 1, 2, and 3, unquote. It was further added, and I quote, the crucial aspect of offense of terrorism is the creation of intense fear and anxiety, both physical and psychological, in the mind of members of the public, which has the effect of coercing, forcing, intimidating them to do or abstain from doing any act or to adopt or abandon a particular view, policy, or position to act according to certain principles, unquote. See also the case of Berende versus Federal Republic of Nigeria, titled Teaching Guide on International Terrorism. Definition, causes, and responses, where several definitions of terrorism were given as follows. I quote, the calculated use of violence, the threat of violence, the calculated use of violence, the threat of violence to inculcate fears, intended to coerce or to intimidate governments or society in pursuit of goals that are generally political, religious, or ideological, and clandestine organized violence by a group which aim is to influence a psychological target in order to make it behaved in a way which the group desires. See JMT track. See JMT track. The unlawful use of force or violence against persons from all the definition above is an act of violence. Threat of violence intended to cause fear, put the recipients of such violence or threat in a state of fear. Applying the above definition to the facts of this case, the defendants in several of these broadcasts made several threatening harms to the federal government of Nigeria, the general Nigerian populace, including in an interview with in an interview with Sahara TV, contained in Exhibit PWW. The defendant was interviewed by one Rodolphe Okonkwo. He was introduced as the founder and director of Radio Biafra. When the defendant appeared on the screen, his nameplate was Nnamdi Kanu, director Radio Biafra. While speaking on the national conference in Nigeria, which representative from the southeast as the conference, and he said, if you go there and negotiate any other thing apart from Biafra, you better not come back because our people will. When he was asked about the consequence for this representative, including one Ike Nwanchuku, the defendant was unequivocal when he said, things have changed, and that because the only language that people in the zoo understand is language of violence and force. After all, that very contraction was put together by Frederick Lugard by force. That is what many people said. Interview kept referring to the southeastern part of Nigeria as Biafra. The defendant made some minutes, 30 second. I have never seen where you will become free by peaceful means, unquote. The defendant also lent support for violent acts when he said he welcomed what a group known as Biafra Zionist group did when they unleashed violence at the Enugu State Government House. He even said he hoped more people will come out to join his group to overthrow the corrupt and inept persons in administration of the government, stating that Biafra must exist and it is their right to make sure it happens. In the broadcast of 16th May 2021, also contained the world must be prepared for what is to come. I want to let Katrina lungs, and people are dying every day. We have to develop the mindset of after this, which even though NATO is there, NATO is there. We say that we are ready to die, and everyone that comes to the Romans because they were too stubborn. Go and ask how they did it. They bombed them, the Romans, away. Not these roadside bombs. Every road leading to Biafra will be landmine. Everything that is Nigeria, whether it is police, army, will blow till the kingdom come. Very neat and simple. Very neat and simple, unquote. The defendant also stated in that same broadcast, and I quote, we are asking for our freedom, and they are listening. But when we start doing what we want, the whole world will start begging us, and then I will come out from wherever I am and tell them that it's too late. Throw away your phones. Remain incommunicado as we are in the state of war. It will not kill you to do away with your foes. All people should go into the bush and stop the advance of this army, or else they will kill you. Unquote. These words spoken by the defendants in those broadcasts were not mere words, as they bear heavy traces of threats to harm people, including international representatives representing their nation in Nigeria. The said broadcasts were several in numbers, and defendants kept repeating his rhetorics that people will die if Biafra is not created. The defendant plan to commit the terrorist act did not only manifest in his broadcast, but was shown in a meeting he had with other Igbo people in the United States. At a World Congress, Igbo Congress meeting held at the 4 Points Hotel in Los Angeles, in the United States of America, has contained that the best way to defend ourselves is to be armed, because Boko Haram is everywhere in zoo called Nigeria. So we need guns and bullets, and those of you in America will give it to us. Also, on the 22nd day of this month, something will happen called the blood moon. Most of you don't know that just before the Civil War, there was blood moon. There was blood moon in 67, and it only happens once in a while, because after this year, we will be free, no matter what happened. If we don't get Biafra, everyone will live to die. We are not joking. South, and some middle belt states from the Federal Republic of Nigeria to form Biafra. The defendant was also bent on achieving his objective with the use of violence, not place any evidence before this court to explain the contents of the said broadcast, or any reason which may be exculpatory in his favor. Having relied on the uncontroverted evidence of the prosecution, this court therefore holds that the prosecution has established count one of the charge beyond reasonable doubt. Consequently, the defendant is hereby convicted in respect of count one. With respect to count two of the charge, the defendant was charged with making a broadcast received and heard in Nigeria with intent to intimidate the population, issue deadly threats that anyone who flouts said a sit-at-home order should write his will, as a result of which banks, schools, markets, shopping malls, fuel stations, citizens, and vehicular movements under Section 1(2)(b) of the Terrorism Prevention Act 20 Acts. The ingredients are similar as contained in count one, except that the prosecution must establish that the defendant indeed issued a threat to anyone who flouts said his sit-at-home order in the southeastern state of Nigeria. The evidence as led by the prosecution shows that the defendant issued a sit-at-home order wherein he threatened the residents of the southeast states from jobs which opened will be destroyed. This was the purport of his broadcast of 30th day of May 2021, where he stated that he had an announcement: lorry, except in ambulance, will be in trouble. I know some people are very foolish, trying to open their shops around 12. If you open that very shop, we will burn you inside it. Against going to church, their places of business and schools. This court wonders if this can be said to be agitation for self-agitations. Unequivocally, I say no. The people of the southeast of Nigeria are entitled to their right to personal liberty, freedom of movement under Section 35 and Section 41, protection of community. F, for the purpose of preventing the unlawful entry of any person to Nigeria or of affecting the expulsion, extradition, or unlawful removal from Nigeria of any person or the taking of proceedings relating thereto, provided that a person who is charged with an offense and who has been detained in lawful custody longer than the maximum period of imprisonment prescribed for him. Section 41, to reside in any part thereof, and no citizen of Nigeria shall be expelled from Nigeria or refuse entry thereby, or exit therefore. They are also entitled to home by a person, especially for someone who is not a legally recognized official of the federal government or an official of any of the states. The only person entitled to restrict movements of persons within Nigeria is the President of the Federal Republic of Nigeria under emergency power under Section 305 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The President can order for a coffee area where there is a crisis or natural disasters. The defendant's power to so declare a seat at home in any part of the country. The defendant arrogated to himself power to relax and with the threat of violence, order the residents of the southeastern states to stay at home or face the consequences of their disobedience. This is an unconstitutional act which is subversive and amounts to nothing more than a terrorist act. It is also a notorious fact that the people of Southeast have been subjected to sit-at-home threats on Mondays for years now. PW4, who stated that he was stationed in the Southeast, especially in Imo State for some years, gave evidence that Monday sit-at-home is a usual occurrence wherein the town are deserted, even the farmlands. PW4 also gave evidence on the death of one Ahmad Goodluck, a former aide to the former President Goodluck Jonathan, that the said Ahmed Goodluck had been killed by airport meant in pursuant to the order of defendants. Ahmad Goodluck was trying to catch a flight out of Owerri on the 30th day of May 2021 when he ran into a checkpoint by airport and was shot dead. PW4 stated that he was one of those who got to the scene first. It must be noted that 30th of May 2021 was a Sunday, not a Monday, but notwithstanding a terrorist act. The defendants did not present any evidence to rebut this case, the case of the prosecution. Consequently, he admits the evidence as presented by the prosecution. The prosecution has successfully proved count 2 beyond reasonable doubt. Consequently, the defendant is hereby convicted of count 2. With respect to count 3, the defendant is charged with professing to be a member and leader of indigenous people of Biafra IPOB, a proscribed organization in which thereby committing an offense contrary to and punishable under Section 16 of the Terrorism Prevention Act 2013. Section 16 of the Terrorism and Prevention Amendment Act provides, and I quote, any person who is a member or professes to be a member of terrorist group commits an offense and is liable on conviction to imprisonment for a time not less than 21 years. The ingredients of the offense from the above provisions are: 1. The defendant must be a person. The defendant must be a member or professes to be a member of a terrorist group. 3. The terrorist group must have been not now, not tomorrow, not forever. We will rather all perish and die than to allow our land to be taken over by the Janjaweed. This is a warning to all the governors who are our watch. We are being told that some of these invaders come from Senegambia, Mali, from Niger, Senegambia, Mali, from Niger Republic, and some from that reads, and I quote, notice is hereby given that by the order of Federal High Court, in suit number FAC/ABJ/CS/A71/2017, dated September 20, the activities of indigenous people of Biafra are declared terrorist and illegal in any parts of the country, as prescribed pursuant to Section 2 of the Terrorism Prevention Act 2011 as amended. 2. Consequently, the general public is hereby warned that any person or group of persons